Hello, everyone, and welcome to this edition of the USPTO Hour series on PTAB updates and priorities. I'm lead judge Ifti Ahmed from the Patent Trial and Appeal Board, and I'll be your moderator today. I'm pleased to be here today with our Chief Judge, Cal Deshpande, Acting Deputy Chief Judge, Michelle Ankenbrand, Acting Vice Chief Judge, Jeff Abraham, and Acting Vice Chief Judge, Stacy White. We hope to cover quite a few topics today and also take some questions at the end. But before we get started, a couple of things about questions. If you have questions about today's topics, please don't put them in the chat. Please email them to us at the address that you see on your screen, usptohour@uspto.gov. You can find this address in the chat during the presentation. And a couple of tips on questions. Please email your questions as soon as you can. It takes us some time to process your questions and present them to the judges. Also, make your question direct and focused, 1 or 2 sentences at most. Questions that are longer than that are difficult to address in this format. So we welcome your questions. And I'd also like to remind everyone that copies of the slides from this presentation and a video recording of this presentation will be posted to the USPTO Hour website in a few days. So without further ado, let me hand it over to Chief Judge Deshpande to get us started.
Thank you, Judge Ahmed. Can you hear me okay?
Yes.
Great. Hi, everybody. It's good to be back at a USPTO Hour, and thanks for having PTAB today. We have a full agenda of topics laid out for today, and we're going to make sure we get through all of them. But like Ifti mentioned, if you have any questions, please do send those along. Our agenda for today is we want to revisit sort of the PTAB institution guidance. We also want to go over search disclosure declarations. We've got a couple of interesting topics on real party and interest and director decisions on deinstituting proceedings or review. And then we want to wrap it up with going through some of our statistics, both on the appeal and trial side, and then talking about some of our precedential informative decisions. And of course, at the end, we will take all the questions that come in. I just wanted to take us back through sort of a little bit of guidance that has come out in the past year, and then we'll talk a little bit about some more of the recent guidance. Last March 26th, Acting Director Stewart issued the interim processes memorandum. This is the memorandum that bifurcated the institution processes into 2 parts, a discretionary portion and a merits consideration portion. The goal of this process was to improve efficiency, make sure that PTAB had the capacity to continue to conduct trials, reduce ex parte appeal pendency, and then also, and importantly, to promote the consistent application of discretionary considerations in each of the proceedings so that the same facts are received the same treatment across all the proceedings. During this initial portion of the process, the discretionary considerations, the office issued a lot of decisions, over 600 of them. Were issued under this process. So there's a wealth of information out there as to how discretionary considerations are evaluated and reviewed. And there's, as we'll talk about at the end, we flagged and highlighted several cases for precedential and informative consideration to provide the transparency to see how the office is reviewing all of our discretionary considerations. Later last year, Director Squires issued a memorandum on institution. This memorandum brought the merits portion and merits and non-discretionary portion back to the director. This is how it is expressly laid out in the statutes that the director handles decisions on his institution. And so this portion was brought back to the director, and now the director issues decisions on discretionary considerations and on the merits considerations. So there are notices that issue weekly that identify which cases have met the merits portion for the threshold for institution and which cases are referred to a further merits consideration once it passes the discretionary consideration. Again, this was done to improve efficiency and consistency, to make sure that all cases are evaluated with the same light. And of course, this was done to adhere to statutory requirements for trial. A little bit more of recent guidance I wanted to highlight. This guidance involves American manufacturing and small businesses. We've heard from stakeholders that the availability of IPRs and PGRs is important to protect American manufacturing and small business. The data, however, kind of tells a different story. The data identifies that a lot of our IP-intensive technologies are in fact manufactured overseas, and that small business users are not the primary users of AIA reviews. And so the director issued a memorandum to take into account additional discretionary considerations. We'll talk about those on the next slide. But really, these new considerations help the office collect information about the institution framework and make sure that the consideration factors are weighed accurately and consistently to make sure that small businesses and domestic production are also taken into consideration. What are these considerations? We've highlighted them just kind of in three sort of factors. The first one is the extent of any accused products in parallel proceeding. For what that means in PTAB is that what are the petitioner's products and are those manufactured in the United States? The second one is what are the patent owner's products? Are those manufactured in the United States? And three, whether the petitioner is a small business that has been sued for infringement. Again, these are considerations. Whenever discretionary considerations reviewed, it's a holistic approach. There's not any one consideration that necessarily trumps everything else, but these are important for the director to review and consider based on stakeholder feedback. We wanted to ensure that all considerations are given and are weighed appropriately in determining whether to deny a petition based on discretionary considerations or to forward it on for a merits review. So the office is encouraging parties to bring in evidence and arguments that highlight these three prongs to make sure that the office can properly evaluate the considerations for a given proceeding. I'm going to turn it over to the next slide, and I think I'm back to you, Ifti.
Yeah. Just a reminder that if you have questions or comments about today's presentation, please email them to usptohour@uspto.gov. The next item on our agenda is search disclosure declarations, and I'll hand it over to Judge Abraham to present that.
Thanks, Judge Ahmed. So the next topic we'd like to talk about are search disclosure declarations. Hopefully you've heard of these. These are a result of a November 17th, 2025 memo from Director Squires announcing the practice where petitioners and IPRs and PGRs can voluntarily submit information describing how the asserted prior art in those petitions was identified. And so what we had been seeing is that there are oftentimes art that was asserted in petitions was not identified during examination. And so the question arose as to why that was happening and how we could figure out ways to fix that. And so the goal of the process was to identify enhanced ways of searching to improve examination quality, and input from the stakeholders we thought would be a great way to kind of bridge that gap. So in the memo from Director Squires, it identifies certain types of information that these search disclosure declarations can include. And among those topics are the databases and repositories in which the asserted prior art was located, general search terms, queries, the pathways employed, other analytics, and then also the amount of time spent on the search and the amount of time spent reviewing the results, because that type of information is also beneficial in terms of determining, how to enhance search procedures at the office. And so what's the result of these search disclosure declarations? Why should you submit them? Well, a voluntary submission of a search disclosure declaration can be considered and will be considered as a non-exclusive, non-dispositive, favorable discretionary factor supporting institution. This is particularly the case where disclosure declaration reveals new or underutilized pathways that's relevant to office search practice. Again, the goal being seeking ways to enhance searching and improve examination quality. And so listed on the slide is a case where the director discussed the submission of a search disclosure declaration and how it was a favorable factor in the discretionary considerations process. Another example of how search disclosure declarations can be beneficial is that it may be helpful in demonstrating office error, which is another favorable factor in the discretionary consideration analysis. And so just a couple of statistics we received close to 50 search disclosure declarations so far. They are reviewed at the board. They also are reviewed by other business units at the office. again, it's a feedback loop. It's used to enhance examination. And so we're trying to take the information that's provided in these declarations and improve our processes internally. As a reminder, and as noted in the memorandum from Director Squires, is that you can file these declarations under seal as filing party and board only. They can be subject to in-camera review. That way you're not disclosing information publicly that you don't want disclosed that way. And you could also generally there will not be deposition testimony permitted, absent exceptional circumstances on the information in the search disclosure declaration. The hope is that this encourages folks to submit these search disclosure declarations to help us improve patent quality, help us figure out ways to identify art that's coming up in these petitions that wasn't identified during the examination. And with that, I'll turn it back over to Ifti.
Thank you, Judge Abraham. Once again, the email address to send questions is usptohour@uspto.gov. The next topic we'll cover is real party and interest. And for that, I'll hand it over to Judge Ankenbrand.
Thank you, Judge Ahmed. So before I start to talk about real parties and interest, I think it's important to kind of set the context for the issue. If you've heard Director Squires speak about his policy goals for the PTAB and AIA reviews, he has identified knowing who is behind a challenge before the office decides to institute a review as one of his 4 pillars that guide policy in AIA reviews. And this is important because it allows the office to manage conflicts of interest accurately, ensure that estoppel provisions are being correctly applied, and also to address national security concerns, which I'll touch on in a moment. Consistent with this pillar of knowing who is behind an IPR or a PGR, one of the first things Director Squires did upon becoming director was to de-designate the board's Shark Ninja decision. Subsequently, Director Squires designated the board's Corning Optical decision as precedential. And these first 2 steps kind of form the context behind how Director Squires has looked at the real party and interest requirement. So what you see on the slide before you now is just a general timeline of how Director Squires has thought about and decided real party and interest issues. So again, you'll see all the way to the left, the first aspect of that was de-designating Shark Ninja. And for those of you who need a refresher, under the Shark Ninja decision, the board did not need to address RPI issues unless a time bar or estoppel was implicated. So Director Squires de-designated that from precedential status, and then about a month later, designated the Corning Optical decision as precedential. As the director noted in his memo explaining his reasons for designating Corning Optical as precedential, there have been parties that have been deemed national security threats filing a substantial number of AIA petitions. In fact, in the memo, Director Squires noted that if treated as a single filer, they collectively would have been among the top 10 IPR petitioners for the period from 2019 through 2024. So we start with that October 2025 designation of Corning Optical, and then some other decisions followed from that. So we have in January 2026, the Yangtze Memory Technologies case, which I'll talk about a little bit later. We also have in February 2026, the de-designation of Propent Express Investments and Adello Biologics versus Amgen. Those, both of those decisions essentially addressed what the board looks at when determining whether a petitioner can amend or update its real party and interest identification. Then shortly thereafter, on February 25th, 2026, Director Squires issued a decision in the Curium case, and that decision was designated informative on issuance. And then finally, on March 18th, 2026, Director Squires issued a decision in Tianma Microelectronics, and that decision was designated precedential on issuance. So turning to these decisions, what do they basically say? So Corning Optical sets the standard for when the office will evaluate RPIs under 35 USC section 312A2. In that case, as you can see from this slide, the board determined that under 312A2, it cannot consider a petition unless the petition has identified all RPIs. And the board also granted the patent owner's motion to dismiss the petition and terminated the IPR after finding that the petition failed to identify all RPIs and that according the petition, a new filing date would mean that the petitioner was time barred. So even if the board were to give the petition a new filing date, at that point in time, the board would not be able to institute review because the petitioner would have been time barred. So the kind of the takeaway from Corning Optical is that under the decision, the office is going to enforce section 312A2 requirement that a petition must identify all real parties in interest for it to be considered. And this enforcement allows patent owners or the office to surface RPI issues early in a proceeding. And again, I think I said this at the outset, the reason we want to do that is to identify conflicts of interest, ensure estoppel provisions are correctly and fairly applied, and also allow for RPI discovery as appropriate. So the second decision that Director Squires issued as informative, which is the Yangtze versus Micron decision. In this case, I kind of look at this as setting forth the burdens for the office's RPI analysis. So essentially what this case says is that when a patent owner comes forward with evidence sufficient to put the RPI issue into dispute, then petitioner has the burden of showing that it has identified all RPIs in his petition. So essentially, this decision applies the Federal Circuit's Worlds v. Bungie case. And here, the director vacated institution and denied the IPR because petitioner failed to provide clarity as to its actual ownership, which was fatal to the petitions. And again, in looking kind of at that burden shifting for RPI, in this case, the patent owner came forward with evidence sufficient to put the RPI issue into dispute, and the petitioner failed to rebut the evidence or carry its burden to show that it had named all RPIs. So what happens when a petitioner decides to amend or update its mandatory notices to identify new RPIs? This is essentially what the Curium decision addresses. Again, this was issued as informative. And in this case, the petitioner updated its mandatory notices before institution. And the decision looked at the updated mandatory notices, concluded that they appear to meet the statutory requirement under 312A2 to identify all RPIs, and different from Corning, but consistent with Corning. In this case, according a new filing date to the petition would not have implicated a time bar or estoppel under section 315. So in this decision, the director accorded the petition a new filing date. And then kind of rounding out the RPI decisions is the decision in Tianma, which was designated precedential on issuance. And the kind of the takeaway from this, or this decision addresses what happens when a foreign sovereign is a petitioner or potentially an RPI in a proceeding. And so in this decision, the director interpreted and extended the Supreme Court's return mail decision to foreign sovereigns to put the US government and foreign sovereigns on equal footing. So the actual holding is that under return mail, the director's broad institution discretion, a foreign government is not a person under Section 311 that's permitted to be a petitioner or an RPI in an IPR or a PGR proceeding. And here the director denied institution after applying the burden shifting framework from Worlds and Yangtze. Before we turn to decisions deinstituting review, also I wanted to highlight another recent decision on RPI from the director that applies the Tianma decision, and that is the TikTok decision issued a few weeks ago. Again, it applies Tianma and also, I think, importantly notes that a post-institution change in ownership may mean that a company can file a petition going forward, but has no effect on the RPI analysis in the case at hand or the current case that the office is considering. So now turning to decisions deinstituting an IPR. There's been some discussion lately about the director deinstituting IPRs after institution, but before the board issues a final written decision, or on occasion after the board has entered a final written decision in a case. So we kind of wanted to talk about some of the Federal Circuit cases that have guided the director in this area, and those are up on the slide. So there is some Federal Circuit authority that permits the office to deinstitute an IPR or a PGR even after the board has entered a final written decision. There are 3 cases highlighted here: Medtronic, Biodelivery Sciences, and Sling. All of them have a little bit of a different kind of flavor or a way they address the issue, but essentially the holding that permeates all of them is that decisions to terminate IPRs without a final written decision constitute decisions whether to institute an IPR and are final and non-appealable. I point out Biodelivery Sciences because in that case, the Federal Circuit affirmed the board's decision to revisit institution after the SAS decision and to terminate the proceeding, even though the board had already entered a final written decision. And then the Sling TV case is also cited, basically just kind of affirming the authority for the board's decision to institute IPRs. One thing that we've seen come up is a question of how often does deinstituting an IPR occur in practice? And so we wanted to highlight some of the rare instances where the director has deinstituted or terminated an IPR, either after institution but before a final written decision, or after a final written decision. So there have been 2 circumstances where the director has instituted or deinstituted or terminated an IPR after institution, but before a final written decision. And in those circumstances, the first was where a petitioner failed to identify or failed to carry its burden to identify a real party in interest. Though that has happened in the TikTok cases, which we just discussed in terms of real party in interest, and the case numbers are there. And then the second instance has been when another tribunal has already determined that the same patent claims were not invalid based on the same prior art and arguments that were raised in the IPR. And that case is the Sinclair Pharma versus Hydrofacial case that's listed up on the slide. There have also been a few rare instances where the director has deinstituted or terminated an IPR after a final written decision. And the circumstances are set forth on the slide here. Again, there's been a termination after a final written decision where a petitioner failed to identify a real party in interest. That's the ILO Free Sites case. Also, we had one instance where the patent claims had been challenged 7 times before, including in a separate IPR that had already concluded that the same challenged claims are unpatentable and was currently on appeal to the Federal Circuit, and that's the Verizon versus Omega Patents case. And then finally, we had one instance where a petitioner's expert was not credible as to multiple material aspects of his testimony, and therefore it would have been inappropriate for the board to rely on that testimony in rendering a final written decision if the director was to remand the case back to the board. And that was the interactive communications case, which is also listed on the slide. So I'm going to turn it back to Judge Ahmed.
Thank you, Judge Jenkins-Bryan. Another reminder about questions. If you have questions about anything that was discussed so far, please send them to this email address, usptohour@uspto.gov. Now let's turn to some statistics. Judge White will discuss ex parte appeal statistics. Judge White.
Thank you. As Judge Ahmed said, I'm Acting Vice Chief Judge Stacy White, and in this segment, I'll be reviewing our ex parte appeal statistics. The board has worked very hard over many years to bring down our inventory of pending ex parte appeals. As many of you may recall, our high water mark was back in fiscal year 2012 when the pending inventory reached 26,570 appeals. Since then, sustained effort and disciplined case management have driven that number down dramatically to just 1,866 pending appeals as of March 31st of this year. That's a reduction of more than 90% from the peak, or more than 24,000 pending appeals. This matters because a smaller, healthier inventory translates into shorter and more predictable pendency for applicants, as you will be able to see in the coming slides. As shown on this slide, the reduction in appeals inventory has allowed us to reduce the time that appeals are pending before the board. In just the last year, we have achieved a striking reduction in maximum pendency, down from just over 2 years or 28 months as of May of 2025, all the way down to just over 9 months as of April 1st of this year. All of this has led to strong reductions in the average time that an appeal is pending before the board in all technology areas. The top numbers that you see on the slide in gray are the average appeal pendencies for the period of January 2025 through March 2025. As you can see, during that time period, we ranged from a high of 16.8 months average pendency down to a low of 10.5 months, excluding re-exams, which I'll touch on in a moment. The numbers in the colored bars are for the period of January 2026 through the end of March 2026. And as you can see, average pendency is way down, with average pendency now ranging from between 8.7 months to 7.1 months. And re-exams, as I mentioned before, have always been handled with special dispatch. And in the previous time period from that time period in 2025, average pendency was just 5 months. But now we have pressed that pendency all the way down to less than 3 months. All of this together has led us to having an overall pendency across all technology areas of an average of just 7.6 months. Now I would like to share a quick snapshot of our ex parte appeal outcomes so far this fiscal year. As of the end of March, we've decided nearly 3,000 appeals, 2,907 to be precise. Of those, approximately 60% resulted in an affirmance of the examiner's decision. About 32% resulted in a reversal, and in about 8% of appeals, the outcome was mixed, with some things being affirmed and some things being reversed. Now I'd like to pass it back to Lead Judge Ahmed.
All right, let's go over some of our trial statistics. I'm going to try to make statistics as exciting as I can possibly do. I know Judge White just did a great job of that. But I wanted to highlight some of our trial statistics, really based on some landmark moments that have happened in the last year. I talked about some of these at the beginning of our presentation, but I think it was important to look at some of our trial statistics as we have issued some memorandum and guidance and some procedural changes along the way. So you can see on our petitions filed slide, you can see that we've demarcated 3 lines in our timeline here. The first is when the interim processes memo, interim procedure memo was rescinded. That's the memo that was issued by Director Vidal, and then the bifurcated memo is issued in March, and then the third memo, which is the Director Squires memo. So these are 3 points where our procedures were changed along the way. And you can highlight a little bit of why some of the statistics might be leaning in the directions that they're leaning. So you can see last January, when the interim procedures memo was rescinded, we were averaging we're around 140 petitions in that month, and around or between 120 and 140. And as the bifurcated memo came out, the statistics for petitions filed stayed pretty steady all the way until the Director Institution memo was issued, where we hovered around 90 petitions. And then you can see the last few months as between 35 and 55, I think is where the petitions filed statistics are. This is a color slide that let me explain a little bit before we dive too deep into it. We have numbers on the left, and then we also have percentages on the right that are unrelated. So the numbers on the left are the total numbers, so they relate to the bar graph portion of the graph, and the numbers on the right are percentages that relate to the green line across the middle. What we really wanted to show here was sort of a month-by-month analysis of what the institution rate really is. You can see that the starting point, which was 2 Octobers ago, we were around a 95%, around a 65% institution rate or 64% institution rate, and it ends in February, where the overall institution rate is around 37%. And you can see that the institution rates is where there are grants are higher than the institution denied rates, all the way until June of last year, where denials superseded the institution grant rates and have stayed steadily a little bit higher all the way from last July through this past February. But the green line gives you the graph of where the institution rates have sort of fluctuated between 2 Octobers ago and right now. It's between just under around 67% to where it is now at around 37%. Again, we wanted to demark out sort of those important moments over the course of the last year, but what this slide shows is the shift in institution as to who's doing them. The light blue and the light pink are identifying when a panel has done an institution decision, whereas the purple and the mustard and the blue are getting us to when the director has taken an action. So you can see the transition as it goes through time. After the bifurcated memo issued, we still had majority panel decisions that we're issuing. And then you can see as the mustard graph it comes onto the chart, is where the director is now issuing decisions, and that director portion, as we get to December, you can see there's more director merits decisions, there's more director merits granted, merits denied, as well as director discretionarily denied. And as we get to February, you can see the panel decisions have been sort of phased out, and over the transition of this timeline, you can see it's gone from the panel decisions to the director decisions. Similarly, here you can see the merits determination rate, whereas with the panels last June, we're looking around just over an 80% merits institution rate, and then this past February, just on the merits alone, it's just around 77%. And you can see how the panels, again, the shift between panels issuing decisions to the director issuing decisions. So again, we demarked out when the director institution memo issued last October, and that sort of signifies the shift in between, sort of a change in process and procedure where now that the director is handling the institution decisions. I will turn it back to you, Judge Ahmed.
Thank you, Judge Deshpande. One last call for questions. If you have questions or comments, please send those to us now. And turning to the last topic on our agenda today, presidential and informative decisions, I'll hand it to Judge White.
Thank you. Good afternoon. Now we'll move on to a discussion of some recent precedential and informative decisions across both AIA and ex parte proceedings. First up, I'll start with some recent decisions regarding claim construction. In particular, I'd like to point out the two Revo versus Cerebrum decisions. These decisions establish that petitioners must keep their claim construction positions consistent between the district court and the PTAB. Revo took one position in district court and a different one in its IPR petition, without explaining why the change in claim construction position should be allowed. The director held that this violates the rules and applies to all claim terms, not just 112 terms, and is a serious enough issue to block institution. The first decision vacated institution for failing to address the inconsistency, and the second reversed institution entirely, noting that it is insufficient to argue a different claim construction before the board just because a district court may reject a petitioner's proffered claim construction. Instead, a diverging claim construction position may be acceptable when the district court has already rejected petitioner's construction. The takeaway is an unexplained inconsistency is generally fatal to a petition. Issues like this should be raised early in a proceeding, preferably in discretionary briefing. Typically, there's no reason to wait until the patent owner preliminary response. Just bring it up early so that it can be decided and determined quickly in the proceeding. Now let's move on to cases that are discussing and fleshing out the settled expectations factor in 314A, one that can tip the scales against institution when reliance interests are truly entrenched. This was first applied in the DeBico Airport Solutions versus AXA Power case. There, the acting director denied institution based on settled expectations. That decision underscores two key points. One, a petitioner now bears an affirmative duty to explain why institution won't disrupt established reliance interests. And two, if those interests are found truly settled, then institution may be denied in the office's discretion. The Apple v. Alani case further fleshes out the contours of settled expectations. There, the petitioner knew of the patent for over a decade, but explicitly decided not to take a license and informed the patent owner of this. The patent owner then refrained from enforcement activities until 11 years later and after the patent itself had expired. That long course of conduct weighed against a finding of settled expectations. Another spin on this issue occurred in Home Depot versus H2 Intellect. There, the challenged patent lacked any real footprint in the petitioner's business. Although the patent had been asserted against technology devices such as tablets and smartphones, the petitioner was a hardware retailer. And in this circumstance, settled expectations were not shown and thus did not weigh against institution. Finally, I'd like to point out the Top Glory Trading Group case. In Top Glory Trading Group versus Cole Haan, there the petitioner was able to demonstrate how a change in the legal landscape eroded reliance interest. The petitioner showed that a significant shift in design patent law had altered expectations regarding obviousness of design patents, and this shift was so fundamental that institution was appropriate in this instance. Taken together, these decisions make clear that when petitioners cannot show that institution would not disturb a bona fide settled expectation, or where petitioner can show that legal or factual circumstances have unsettled those expectations, the office will decide whether to exercise its discretion to deny institution. Now I will hand things off to Vice Chief Abraham to discuss some additional precedential and informative cases.
Thanks, Judge White. So This slide has several different cases, different topics on informative and precedential cases. At the top, we see some cases on joinder. And the takeaway from the Realtek semiconductor case is that although 315B permits joinder of time-barred parties, absent exceptional circumstances, these types of petitions will be discretionarily denied. So if you are a time-barred party and you're seeking to file a joinder petition, it's essential that you describe what exceptional circumstances apply to your situation to avoid discretionary denial. The next case on joinder, the Elong case, is more of a procedural decision. It explains that for joinder request, it's kind of a dual analysis. First, the discretionary considerations will be analyzed based on the second petition that's filed by the party that wants to join. And then the discretionary considerations are also considered for the case that the party seeks to join. And so it's just more of a procedural analysis there, but it's important to follow and take those things into consideration if you are filing a joinder request with your petition. The next case here talks about an issue that Judge Ankenbrand already described, that when there's a petition that challenges claims that have already been found invalid in another forum, that petition is likely to be discretionarily denied. The Tesla Intellectual Ventures case, this one was a decision where the case was referred, so it got through the discretionary considerations analysis. And the basis there was that there was several different patents that were challenged in multiple IPRs. They had diverse subject matter. They were all part of a related litigation. But the fact that there was such diverse subject matter and a high number of patents made the board better suited to handle the patentability challenges. And so that was the critical factor in allowing the case to move forward onto the merits considerations. And the last case here, the Pedagis case, this is another issue that we've discussed earlier today, is that the explanation of apparent error during prosecution, that's a story that if you can tell that you'll want to tell, because it is an important discretionary consideration. And it is one that usually, if it's successfully explaining error, will be a favorable discretionary consideration. Here, the first couple of cases on this slide deal with multiple petitions. So when you have multiple petitions challenging the same patent, when might that be acceptable and when it will not be acceptable? And so we can see here from the CrowdStrike decision that if a petitioner files multiple parallel petitions challenging the same patent, in this case, they use different claim constructions. The board will institute at most one. Usually the board will pick which claim construction is the best and will move forward with that petition. The LifeVac case talks about where there was a PGR and an IPR filed, a serial IPR filed on the same patent. And it explains that just because the PGR, the IPR is filed after a PGR that was discretionarily denied, the IPR will not be discretionarily denied solely on that basis, solely on the basis that it follows a PGR. And the theory here is that we want to encourage parties to file PGRs. And so there won't be a penalty filing a serial IPR if a PGR has been denied. The next case, the Pacific Corp case, again, which refers to multiple parallel IPRs being filed. The board is at most going to pick one to move forward with. The last case in the multiple petitions category here is an instance where multiple petitions may be justified and may be allowed. And that's when, in this case, the specific example was after an IPR had been filed on a patent, in a district court proceeding, a patent owner asserted new claims. And so the petitioner needed to file a new petition to address those claims that had been newly asserted after the original IPR had been filed. So that was one situation where multiple petitions on the same patent was permitted. And the last slide we have here on the last case we have on this slide is just one that emphasizes that filing a PGR is a consideration against discretionarily denying the petition because PGRs are favored, early challenges are favored. This slide captures some longstanding issues, 325D, some cases that relate to that, cases that relate to identifying RPIs, which Judge Ankenbrand covered, and then the Desjardins case, which addresses 101 eligibility. And with that, I'll turn it back to Judge Ahmed.
Thanks, Judge Abraham. And if you want to see a list of our presidential and informative decisions, you can visit our website that's linked over here. As I mentioned, these slides will be posted to our website in the next couple of days, so you can find the slides there. Now turning to some questions, we've received quite a few. I'll start with Chief Judge Deshpande. Is there a panel of judges that assist the director with institution decisions? And if so, do the judges have relevant technical expertise to work on the case?
Yeah, the director has several judges that help with the institution decisions. So I kind of, as I highlighted in the beginning, there are the discretionary considerations, and then there's the merits and non-discretionary considerations that the director reviews. The director has several judges helping with both parts of those considerations. A lot of the judges dig into the cases, they review the case files, they break them down in ways that are easily digestible for the director and the deputy director to understand. There's a lot of discussion that evolves from a lot of the judges' interplay with the director, but ultimately the director makes the decision. But he certainly has a lot of help and support from PTAB judges to get to his answer.
Okay. And while I have you, this is probably a good question for you. Will there be a webinar to help pro se filers?
That's something that I think we can, if there's enough interest, we'd be happy to do a pro se webinar to help our filers. I would encourage for those that are pro se to take a look at the USPTO website. There's all sorts of resources on the USPTO website directed to pro se filers and those that might need any help with any of the processes that happen at the USPTO. Even the PTAB website has a tremendous amount of information available for our pro se filers. There's also pro bono programs for some of our pro se filers that may need assistance from counsel. So take a look at the USPTO website for the pro bono services and some of the pro bono services available at PTAB too.
Okay, thank you. Judge Ankenbrand, this is a question on RPIs. What timing considerations are there on bringing an RPI issue to the board's attention? Does it have to be raised before the patent owner responds, or can it be raised later?
Thanks, Judge Ahmed. So first, RPI is a real party in interest. So that's what we're talking about when we're referring to RPI in the short form. Generally, it's best to surface RPI issues as soon as you identify them if you're a patent owner. So the advice I would give is that if you think there's an RPI issue, once you review a petition and the mandatory notices that a petitioner has provided, that's the time when you should raise the RPI issue with the office as soon as you first identify it. Now, obviously, if the RPI issue doesn't occur until later in the case, then you can identify it later. But generally speaking, under Corning Optical and some of the other precedent, we're trying to surface these issues early in a case before a case gets through institution and gets assigned to a panel of judges, because at that point in time, if a new RPI issue arises while we have a panel on the case, it definitely is a more complex consideration than with respect to things like conflicts of interest. So what we're looking for is for those issues to be surfaced as early as possible. And if you think there's an RPI issue and you have enough evidence to make out the issue, but you may be missing some evidence as a patent owner, don't be afraid to ask for discovery into real party and interest. Again, I would advise parties to be, or patent owners to be, guided by the board's Garmin factors. So if you have no evidence that there's an RPI issue, it's going to be a lot more difficult to get RPI discovery. So you really need to crystallize the issue and show or point to some evidence in the record that raises a question about real parties and interest, and then you can ask for discovery that's narrowly tailored to help the office determine whether there is an issue that needs to be addressed.
Okay, thank you. The next question is for Judge White. Judge White, while discussing the Dabico decision, you mentioned that the petitioner has an affirmative duty to show why patent owner does not have settled expectations. So the question is whether that duty applies at the petition stage itself, or does it only arise when patent owner files a discretionary denial request?
Well, that is a discretionary issue, but it's important that petitioners know that they need to tell their story, and they need to get their information out front and in front of the board and the director as soon as possible. So there's no reason to wait and not address those factors just so that you can have your story out there. Discretionary denial is something that is really in the hands of the director, because we're not required to institute any cases. So you want the director to know why this is a case that should be instituted, and there's no reason not to put that in your petition and get that out front immediately.
Okay. Judge Abraham, this question is for you. Can you tell us what goes into giving the search disclosure declaration a favorable factor supporting institution?
Sure. So the ideal search disclosure declaration is going to have information that reveals new underutilized search strategies or sources, things that the examiners aren't using, techniques that the public is using to find art, and help the office identify similar art. So those are the types of things, outside the box thinking, maybe new search strategies, new repositories, things like that. Those would be the ideal search disclosure declaration. But really, any information is helpful. It can be useful to help improve patent examining quality. So there's really no one size fit all search disclosure declarations. Probably less helpful are ones that are very cursory, ones that do not provide value in terms of helping us improve examination quality. But really, all information is useful. So we do encourage parties to file SDDs.
Okay, thank you. There are a few questions about the recent memo related to American manufacturing. I'll direct those to Chief Judge Deshpande and Judge Ankenbrand. Have you received any discretionary briefs yet regarding the memo on American manufacturing and small businesses? And then a related question is, can a party offer evidence related to either American manufacturing or small business status if trial has already been instituted in the case?
Let me start with the first one. There is a timing consideration that went with the director's additional briefing or considerations on American manufacturing and small businesses. The timing considerations were effective as to whenever they were available, to the point where a patent owner's request for discretionary denial had not yet been filed. So given the timing component, we are likely to start seeing maybe arguments in those areas in the next few weeks, but it's a little bit too early for us to have seen any of those arguments just yet. Certainly, I would imagine this issue may come up on director review, where it'll be post-institution. So let me just turn it over to Michelle to see what's happening there.
We have actually gotten a few director review requests wanting to raise American manufacturing or small business considerations, which we've generally denied, again, due to the effective date of the memo on those considerations. So the answer is post-institution, we're not going to consider those discretionary considerations. The time to raise them is in your discretionary considerations briefing, and they apply, again, so we can have an effective date and kind of figure out which cases the considerations apply to and which cases they don't. The memo sets forth the effective date and what kind of petitions or cases those particular considerations apply to. So if you've already had an institution decision, it is too late to raise those considerations in director review or with a panel post-institution.
Okay, thank you. We've got quite a few questions along those lines, so I'll skip those. Judge Deshpande, may parties raise discretionary arguments in other briefings, such as the patent owner preliminary response?
Good question. No, it's really encouraged that parties put their discretionary arguments in the places that we expect to see them, because of the bifurcated process and the considerations that are evaluated at the time they're evaluated. Parties should really limit their discretionary arguments to the briefing that involves discretionary consideration. So a patent owner starts with a request for discretionary denial, and then a petitioner responds thereafter. A lot of the timing and the outlining of how the briefing is supposed to go is available on the website. On the USPTO website, we have a page dedicated to discretionary arguments. And so we want to make sure that people follow the processes that are set forth there. And that way the arguments and the responses to the arguments that follow along settled expectations or parallel proceedings, we know where they are and we can find them, and that they're related to each other. And the timing is also a part of it, where we don't want patent owners to raise arguments in a patent owner response related to discretionary considerations, where those are being filed around the exact same time as petitioners' response to patent owners' request for discretionary denial. So parties are strongly encouraged and that to limit their discretionary arguments to the discretionary briefing.
Okay, thank you. Judge Abraham, there's a question about inconsistent claim construction positions. Have you come across instances where parties have stipulated not to raise inconsistent claim constructions between the office and district court? And how has the office handled those situations?
Yes, the answer to that question is we have seen stipulations on consistent claim construction positions. The way the office has handled those is that if it's a straightforward, firm stipulation not to raise those inconsistent positions, they have been effective. But conditional stipulations, such as, we agree not to raise certain arguments if instituted, those are not effective. And there's a case that the director authored that addresses that. So if parties are looking to avoid that type of issue, the Revo Tesla issue, a firm stipulation not to raise inconsistent arguments is helpful. Conditional stipulations are not helpful.
Okay, and along the same lines, how should a patent owner alert the director or the board? Should a petitioner take a different claim construction position post-institution, and what relief may be available?
If that happens post-institution, the best bet would be to at that stage, it's probably with a panel. And so it would be best to email the board, the trials email at the board, and to raise that issue and to alert the panel. If it happens before institution, those arguments preferably are going to show up in the discretionary denial briefing. So in the request for discretionary denial from a patent owner, that's the preferred place we'd like to see that. We understand timing may not allow for that. If that happens, then emailing the director DI email address to identify those situations would be the best approach to that.
Okay, thank you. Chief Judge Deshpande, I'll ask you this last question. Has the reduced backlog of ex parte appeals impacted the director's discretionary denial rate, if in any way?
No, they're two separate and independent inquiries. One is related to our trial jurisdiction, and I'm assuming reduced inventory rate that Judge White highlighted as our ex parte appeal rate. So those are two separate jurisdictions and two separate inquiries that are unrelated.
Okay, thank you. So it looks like we've gone past our time. I apologize if we were unable to get to your questions. Thanks for sending them in. I'll also note that some of your questions require further consideration, and we hope to provide you answers in the future. I would like to thank everyone for attending today. I hope you found the information that we presented to be helpful. I would also like to thank Chief Judge Deshpande, Acting Deputy Chief Judge Ankenbrand, Acting Vice Chief Judges White and Abraham, for sharing their time and expertise with us today and for answering questions. You can learn more about our upcoming USPTO hour presentations and access slides on the USPTO website. Thank you and have a wonderful day.